Workplace harassment is a serious issue that affects millions of employees. But when does inappropriate behavior cross the line into illegal territory, and what can you do about it? This video will guide you through the legal rights and steps to take when considering a lawsuit for workplace harassment. Workplace harassment is defined as unwelcome conduct based on a protected characteristic that negatively impacts an employee's work environment. This can include offensive comments, unwanted touching, or discriminatory behavior. For a claim to be legally valid, the harassment must be severe or pervasive enough to create a hostile work environment. There are two main types of workplace harassment: quid pro quo and hostile work environment. Quid pro quo harassment occurs when a superior demands sexual favors in exchange for job benefits or to avoid negative consequences. Hostile work environment harassment involves ongoing offensive behavior that makes it difficult for an employee to perform their job. To qualify as illegal harassment, the conduct must be unwelcome and based on a protected characteristic such as race, gender, religion, or disability. It's important to note that not all unpleasant workplace behavior is considered illegal harassment under the law. Before pursuing a lawsuit, there are several steps you should take. First, document all incidents of harassment, including dates, times, and witnesses. Next, follow your company's internal reporting procedures, typically by informing your supervisor or human resources department. If the issue isn't resolved internally, file a charge with the Equal Employment Opportunity Commission or your state's equivalent agency. The legal process for suing your employer begins with obtaining a right to sue letter from the EEOC. Once you have this letter, you can file a lawsuit in court. It's crucial to act quickly, as there are strict deadlines for filing. During the lawsuit, you'll need to present evidence of the harassment, which may include witness statements, emails, or recordings. Employers can be held liable for workplace harassment if they fail to prevent or address it properly. This includes ignoring complaints, failing to investigate, or not taking corrective action. However, employers may defend themselves by proving they had anti-harassment policies in place and took appropriate action when informed of the harassment. While the prospect of suing your employer can be intimidating, there are important reasons to consider legal action. A lawsuit can help stop ongoing harassment, prevent future occurrences, and provide compensation for the harm you've suffered. This may include lost wages, emotional distress damages, and in some cases, punitive damages. It's important to remember that retaliation for reporting harassment or filing a lawsuit is illegal. If your employer takes adverse action against you for speaking up, you may have an additional legal claim. Workplace harassment is a complex issue, and navigating the legal system can be challenging. If you believe you're experiencing illegal harassment, consider consulting with an employment attorney to understand your rights and options. By taking action, you not only stand up for yourself, but also contribute to creating safer, more respectful workplaces for everyone.